morning, the state versus Novack, he probably had 15 minutes to present the argument. The council may reserve for 5 minutes or rebuttal. Council, how long would you like to reserve?
3 minutes.
3 minutes, thank you. I will be keeping track of time up here. There's no word for you to see it. So I will give you a warning. We have about a minute left in your initial time. I will not give you a warning at the end of the rebuttal time. The council will also give you a 1 minute of your time to die. The argument is being recorded. When you present the argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of any children, minors, or victims during an argument, and you can refer to them by initial or term like the child, whichever you prefer to do. We're ready to read and are ready to proceed whenever you are.
Good morning, and may it please the court. My name is Melissa Siebel, and I represent Ronald Novack. Mr. Novack was deprived of a unanimous jury verdict when the jury found him guilty of burglary. This is because under State v. Gardner, a jury verdict is not unanimous when each of the alternative means of committing a crime that the state relies upon are not supported by substantial evidence. Here, the state provided the trial court and jury with 3 alternative means by which Mr. Novack could have satisfied the with purpose to commit any criminal offense requirement of the burglary statute. That Mr. Novack entered AM's home with the intent to commit either sexual imposition, aggravated drug possession, or theft. However, the state did not provide substantial evidence to support 2 of these 3 theories. Contrary to the state's assertion in its briefing, Gardner does not allow for a jury verdict to stand if some of the alternative means are not supported by substantial evidence.
Counsel, I guess I have a question about, did Mr. Novack concede that the state did present substantial evidence to support the theory of that?
Yes, we did concede that. Gardner requires that the determination that a rational trier of fact could have found each means of committing the crime proved beyond a reasonable doubt, and this is because the right to a unanimous verdict is a substantial right. To find that the state provided substantial evidence to support the theory that Mr. Novack had the requisite intent to commit either sexual imposition or aggravated possession of drugs when he entered AM's residence, this court would need to rely solely on AM's vague testimony and the conclusions that she drew from her interactions with Mr. Novack. For example, to find that Mr. Novack entered AM's home with the intent to commit sexual imposition, a reasonable fact finder would need to rely on her testimony that Mr. Novack's behavior amounted to unwanted sexual contact between himself and AM. However, AM testified that Mr. Novack did not touch her with his hands, made no sexual comments, and that she was unsure if Mr. Novack was aroused. AM did testify that Mr. Novack left a stain on her shorts that she alleged came, quote, from his privates, but when asked how this could have happened, she responded that she did not look. Based on these facts, a juror would need to stack multiple inferences on one another to conclude that Mr. Novack had the requisite intent to commit the sexual imposition. A juror would need to rely on AM's subjective and unsubstantiated belief that Mr. Novack might have had sexual intentions, and they would also need to rely on the inference that the alleged stain on her shorts, which cannot be proven existed beyond her testimony, was not only put there by Mr. Novack, but that it came from, quote, his privates, which AM testified that she did not even look to see if that is where it came from.
Counsel, can I ask you, the state relies on state employee and in relation to burglary statutes, right? Burglary statutes prescribe a single crime that may be carried out in more than one manner or method, and they submit that the jury is not required to unanimously agree as to the underlying offense that a defendant intends to commit any particular crime. Is that your understanding of the law?
Partially, yes. However, the Ohio Supreme Court in Gardner and then affirmed later in Adams that although yes, alternative means the jury does not need to unanimously agree on which alternative means supports their individual decision. However, it does require that all of the alternative means be supported by substantial evidence, which is not the case here.
So in this case, if there was substantial evidence, possession, you would say that they're in the hands of.
Correct, yes. However, it is our position that two of these three theories are not supported by substantial evidence, and if even one of these three is not supported by substantial evidence.
Without a specific jury interrogatory regarding which count they found as for the underlying charge, how do we know which count the jury used?
Well, and that's kind of the central point to Gardner and Adams here, is that we have no way of knowing which of these theories each juror relied upon, so we have no way of ascertaining whether or not the jury relied on, you know, a theory of the case that is supported by substantial evidence. And the Ohio Supreme Court in Adams, which is a case that comes after Gardner, that kind of reaffirms this alternative means test and analysis, says that to go against the idea that each of these alternative means need to be supported, and you know, the idea that only one of them or a few of them would be substantial is premised on a dubious assumption of juror infallibility, that the jury would always disregard an unproven theory and convict on the proven theory. The Ohio Supreme Court goes on to say that that assumption defies experience and common sense.
How the state argues that, and that's just the jury instruction here, and there was no objection. How would the court instruct the jury to ascertain that there was the jury was agreeing on all one count or different counts among the three?
Yeah, so it is not our position necessarily that this is an error with the jury instructions, because the jury was instructed on these three theories. And so essentially my understanding is the premise of Gardner that each of the theories that the jury is instructed on need to be supported by that substantial evidence so that we can ensure the unanimous verdict.
Did the indictment include specific felonies to support the burglary, or just say generally that the trespass occurred on felony?
Based on my recollection of the indictment, which is not super fresh, I'll be honest, I don't believe that specific underlying offenses were named in the indictment.
Did trial counsel object to the unanimous verdict below in any way, shape, or form?
They did not. We are subject to plain error here because of that.
Counsel, I don't have a question.
Yes.
Can you hear me?
Yes.
My question is, you rely on the fact that you said there was not substantial evidence for the other two theories
Yes.
that the state presented. But there was at least testimony on both of those, right?
Yes.
How is it a witness's testimony is not substantial evidence?
While her testimony is absolutely, you know, relevant to these theories, her testimony is vague, and on a lot of the key points that we point to in our brief, the witness is unable to elaborate. So, for example, when asked to further elaborate about the stain that allegedly came from Mr. Novack, she said she didn't look.
Well, does that really matter? But that's the whole point, was she testified that he was rubbing himself against her or going across her body.
Yeah, and her testimony is very vague as to where he was positioned on her body, how, you know, how.
She was in bed, right?
Yes, correct.
And yeah, you take the challenge on how disrobed was he according to her testimony when he got into bed?
I'm sorry.
What level of clothing did he have on when he got into bed?
So according to AM in her testimony on, I believe it's page 200, she did testify that he was clothed when he entered her bedroom and sat on the bed across her legs as she testified.
But counsel, he had on less clothing than when he came into the house, I think, through a window. Is that correct?
Correct, yes, he did take off a jacket and leather chaps that were left behind in the living room with his backpack. A juror would need to rely on her subjective and unsubstantiated beliefs about the alleged sexual imposition, and also the theory that Mr. Novack had the intent to commit aggravated possession of drugs relies similarly on vague testimony. AM testified that Mr. Novack pulled out a bag of drugs and asked if she wanted to do them with her. However, she also testified that she had never seen Mr. Novack or anyone do drugs. She also did not elaborate on the type of drugs or was unable to explain exactly what she saw beyond the description of, quote, a bag of drugs. And furthermore, I did cite to some case law in my briefing that Mere possession of items while trespassing is insufficient to establish that one has the purpose to possess or use those items within the residence. And so based on that, this theory is also unsupported by substantial evidence.
Except the fact that he specifically asked her if she wanted to party with him because he knew that she was a party.
That was her testimony, yes. This court has no way of ascertaining which of these three theories presented were relied upon by each juror in finding Mr. Novack guilty of burglary, and since 2 out of the 3 of these theories are not supported by substantial evidence, the verdict is not unanimous under Gardner. Accordingly, this court should vacate Mr. Novack's conviction. Alternatively, if this court finds that Mr. Novack's conviction was supported by a unanimous verdict, Mr. Novack asks this court to weigh the evidence and find that his conviction is not supported by the weight of the evidence. Because the state's theory of the case relies heavily on AM's testimony, which is unreliable, vague, and inconsistent with the testimony of other witnesses and her own prior statements. In addition to the issues with the testimony that we've already discussed, there are other notable inconsistencies present here. For example, AM denied any association with Mr. Novack, repeatedly calling him weird but unable to provide a further explanation for why she felt that way other than saying, quote, "He just has weird vibes." Despite this, she referred to Mr. Novack as Ronnie 13 times throughout her testimony, and she testified that Mr. Novack allegedly woke her up and that she was asleep when Mr. Novack entered her bedroom, but then also testified that she watched Mr. Novack climb into her window on the live camera feed via an app on her phone. Additionally, she testified that she showed Officer Kovac, who responded to her home a few hours after Mr. Novack left, the stain on her shorts that she alleged Mr. Novack left, but the officer testified that AM had never mentioned such a stain. AM also, I'm sorry.
1 minute left of your comment.
Thank you. AM also told Officer Kovac that Mr. Novack woke her up by saying inappropriate things to her, but then testified at trial that Mr. Novack never made any sexual remarks towards her. Based on these inconsistencies, Mr. Novack asked that this court find that his conviction is not supported by a unanimous jury verdict, or in the alternative, find that it is not supported by the weight of the evidence, and I will concede the remainder of the time. Thank you.
May it please the court. My name is Rick Raley, and I'm appearing today on behalf of the state of Ohio, the appellee in this case, as well as Summit County Prosecutor Elliot Kolkovich. I am presenting an oral argument after my former colleague filed a brief for this case today. I'd like to distill this down to what the defendant is really asking this court to do. The defendant is saying that the trial judge should have heard the jury say, "You're unanimous on this," and said, "Actually, no, you're not. I'm not going to accept your verdict, even though no one asked me not to accept it," and therefore say there should be a new trial. I can't think of a case in Ohio that's held that what should have happened here, and I'd ask you to refer the trial court's judgment here. So there's no defense objection below about jury instructions or about criminal Rule 31, and that is something that should have happened to preserve this issue. Defendants in this country and in this state as well, they cannot just wait until their appeal after they sit on their rights to raise a new argument that was never considered below. Based on that forfeiture, there's procedural reasons to disregard this assignment of error. And I also would emphasize that it's speculative to assume what the jury's theory was for why they found him guilty of verdict here. As was noted in the question from Judge Stevenson, there's no special interrogatory here. There's no jury polling on this special underlying offense. Based on that. Correct, but there are interrogatories that are sometimes requested. And certainly if you wanted to create a case law on this issue, you probably would request an interrogatory. So I've definitely seen them, especially in self-defense cases, but that is something that certainly could have been asked for, so I would not say it's completely impossible.
It seems to me that the argument essentially is that there's insufficient evidence here, and they did make a criminal Rule 29 motion of sufficiency. That was raised to the court. If the court had felt there wasn't sufficient evidence on some of these potential charges to support the burglary, could the court grant a criminal Rule 29 motion?
That's a possibility, yes, correct. I had not thought of that particular procedural quirk to it. That is interesting. I would say that if there was an issue that the trial judge saw with any of these theories, the trial judge could have adapted and said, we're not going to get to the jury. But that's not what the trial judge did.
And you don't at all argue sufficiency in your proof. Should we even consider any argument for insufficiencies that you could raise the issue?
So, you know, in the brief, I did not see any discussion about the substantial evidence. I do think in the factual description, any court can see that there is substantial evidence on all these different theories, based on sexual position, based on drug possession.
On the aggravated possession, what evidence is there on a specific drug that was possessed?
There is no evidence about a specific drug, that is correct. So, you know, perhaps a beyond a reasonable doubt F5 possession charge would have been a little difficult for the state to prove. But this is substantial evidence on whether that kind of offense occurred. And I do think that testimony that he pulled out a bag that appeared to be drugs, he then used them. He said, I know you like to party, do you want to party with me? Clearly shows more than a little bit that there was use of drugs there. And quite frankly, the overall circumstances and surrounding behavior here shows some very aberrant behavior that drug influence certainly could play into. So I think for that, drug possession is certainly something that the jury could have found he was doing.
Is there a difference on the level of proof here that we're not just reviewing an aggravated possession charge, but we're reviewing it in the context of, is that enough for a crime to submit to support burglary?
That's what I would say, yes, Judge. That it's not a beyond a reasonable doubt, you know, that's not a separate charge. It's kind of like an aggravated burglary where you convict on aggravated burglary, but the underlying felony, there's not based on that. Same kind of thing.
Do you agree with their general proposition that Adam tells us that for this burglary charge, looking at the potential crimes that were committed in the first place, that if there's three alleged, typically they have to have sufficient evidence for all three?
I think that there's language to that effect, yes. The problem is that there's still a question of what's the unanimous, what are they thinking on this? And here we really don't know, because there is nothing that in the trial. So they were given a kind of a choose your own adventure option they chose. And they said there's a guilty verdict, we decided this. Everyone says, okay, now let's go forward to sentencing. And that's what the trial court did. And I just can't see that there's a complete rejection of legal norms by doing that. In fact, I think that's very common in house in this country.
Counsel, does it matter that the defendant, the appellant here, concedes the death?
To me, I think that that's really the end of the case. Because it very well could be the jury all decided, you know what, there's a theft, and took the knife out of the house, it's done. I think that very well means this is the case is over. I think the case is also over because the defendant's acknowledging that there is testimony about all these different theories. Although they may disagree with the quality of that testimony, this is a question about sufficiency, substantial evidence, not beyond a reasonable doubt on at least on their one.
And so, counsel, I'm just thinking about State v. Adams and State v. Brown out of the 9th District. And, you know, I think you cite that as applying guidelines stating that the jury unanimity is not required as to the means underlying the capital specification, obviously a different situation. And then in our 9th District case, we say that the Supreme Court of Ohio has rejected the position that due process requires the jury to be informed of and choose between predicate offenses. How does that all work in your office?
I mean, the statute itself just says any felony therein. I mean, they really could have done an instruction that way, and that was not done. They were specifics. They were basically given to the jury. So, you know, harmonizing these cases would be difficult, especially because Gardner itself is a plurality. So there is a lot of area where I think it'd be helpful for the courts to give more explanation, particularly the Ohio Supreme Court. In the extent that we don't have that, though, I think this is not the greatest case to do that because we don't have an interrogatory, because we don't have objections, we don't have factual development, we don't have arguments below, where it's really a great opportunity to provide much needed clarification in this area.
Short of some form of jury article, how are we ever going to know which of the particular charges the jury members found person was guilty?
So, there's a couple that I can think of other cases where, like an OVI case, and the OVI statute says you can't have alcohol in your system beyond a certain point, or you can't be under the influence of drugs. And clearly all the evidence in the trial is about alcohol. But then the judge says it's also alcohol or drugs. Clearly drugs isn't one of the options. That's just a clear, completely applicable item. So that would be an area where maybe this is something where we can discuss more of these theories. Animal cruelty is another one where there's 5 different versions of how you do animal cruelty, but only one is the one that they're focused on the trial. So if there's a circumstance like that, I think that there's more of an opportunity to discuss Gardner.
Counsel, I want to make sure I clarify, because the group of people who were in front of today, which is the town of Tyson, I think everybody's coming out and inviting us here, and thank you for coming too. But my question is, you keep on talking about waiver and forfeiture. Obviously, the court can look for plain error.
Correct, yes. The court can look for plain error. It's a very high standard. I'd say it's about the highest standard you can imagine on appellate review. And there have to be some sort of outcome determinative error that occurs. Even if all that is satisfied, this court could still say, I'm not going to recognize plain error. And I think in a case like this, where the defense is acknowledging one of his theories is a slam dunk, how can we say this is plain error in this particular circumstance? Before I close, I do just want to emphasize that in the manifest way, I would disagree with Ms. Siebold's characterization of the victim's testimony. I would note that the victim's sister also testified. The police officer also testified in ways that corroborated the victim's testimony on certain aspects of what she experienced. They found the defendant's items in the house. They find that the defendant, both the victim and the sister, both of whom are a family member related to this individual or identifying. I think that there's a lot of strong evidence, which is why the jury did find him guilty. So unless there are further questions, I would ask that you refer today, and I'll sit down.
I see none, thank you. And counsel will have a little more than 3 minutes for
Just a few things in rebuttal. First, opposing counsel claims that this is, not rising to the level of, needing to prove beyond a reasonable doubt. I would disagree. Gardner plainly states that each alternative means needs to be supported and be able to be proved beyond a reasonable doubt to support a unanimous verdict under Criminal Rule 31. In terms of Gardner being a plurality opinion, it indeed was a plurality opinion, but the alternative means analysis from Gardner was affirmed in a majority opinion in State v. Adams. And I would also like to point to a 10th District case that I cited in my reply brief, State v. Rawson, which kind of gets to the heart of much of what we've been discussing in terms of plain error and the speculation to assume jury verdicts, etc. Rawson states that because Criminal Rule 31A provides a substantial right affecting defendant's right to a unanimous verdict, that any error, any Criminal Rule 31A error is plain error based on that alone. Rawson also was a case that involved a jury was instructed on many alternative means that were unsupported by the evidence. Similarly, in that case, the defendant did concede that one of the alternative means was supported, and the 10th District does go on to say that despite that, it is still plain error and requires reversal. The 10th District says, instructing the jury on unsupported alternative means, no matter how implausible, violates the right, and we cannot find harmless error in this case while complying with Gardner. And they also note that this reversal does not preclude retrial on the same charge because it does not represent a reversal based on sufficiency of the evidence. The state presented sufficient evidence to support the conviction on one of the instructed alternative means, and the error lies only in the instructions that followed. So we would also concede that the state could retry Mr. Novack based on the the theft offense here. And then I would just finally, in closing, also go back to the idea that, we can, assume that the jury, chose the right theory and went with that. However, Adams explicitly states that the idea that the jury will always disregard an unproven theory and convict only on the proven theory defies experience and common sense. And the heart of Gardner and Adams here are that each alternative means must be supported by substantial evidence for a defendant to have a unanimous jury verdict under Criminal Rule 31A. And with that, I would thank you for your time, and you can see the rest of my time.
Thank you. And thank you to both attorneys today for the case on behalf of the court. We'll take the matter under advisement as a decision in due course. The clerk court will mail a copy of that decision to the upon release. And the opinion will also be available on the Supreme Court website.